Hi everyone, my name is Nitika Goyal and I am an intern at ubAdvocate. Today, in this video, I am going to discuss an important topic of dowry death, which is defined under section 304B of IPC. According to this section, when the death of a woman is caused by any burns, bodily injury or under any normal circumstances within the 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or his relatives in relation to demand for dowry, then it is called dowry death. The punishment prescribed under this section is imprisonment, which cannot be less than 7 years, and this may also extend to life imprisonment. Now, to understand this section better, we will discuss some important ingredients, which are: first, the death is caused by burns, bodily injury or under any normal circumstances. Second, that it should be caused within the 7 years of her marriage. Third, that soon before her death she was subjected to cruelty or harassment. Fourth, that the cruelty or harassment must be for the demand for dowry. And the last one is that there must be cruelty or harassment caused to that woman. Now let's discuss some further important points under this section. That burns, bodily injury or other circumstances can be homicidal, suicidal or even accidental also. The prosecution have to prove that the death is within the 7 years of her marriage and she was subjected to cruelty or harassment soon before her death. There is no fixed formula to prove soon before death, and it depends upon the circumstances of each cases. The prosecution has to prove that there is a cruelty and in the close proximity of the death. It should not be remote in nature, and there should be close proximity between the death of the woman and the demand for the dowry. If the accused wants to escape this, the burden of proof shifts on him to rebut this presumption. Now, we will discuss this important topic with the help of some case laws. First, in Venkateshwarlu case, the court refused to convict the accused under dowry death by saying that there was no prior agreement of dowry between the parents of the girl and the husband or in-laws. Then, in state of Himachal Pradesh versus Nikkuram, the court did not find this judgment right, and they said that the dowry can be demanded after the marriage or even before the marriage, or even it can be demanded at the time of marriage also. Now, there is also an important section related to this dowry death concept, which is section 113B of Indian Evidence Act. According to this section, when it is shown that women have been subjected to cruelty or harassment soon before her death and that it is in connection with the demand for dowry, then the court will presume that the such person has caused the dowry death. So initially, the burden of proof to prove the same is on prosecution, that he has to prove all the essential elements of dowry death. Once he has proven the same, the burden of proof shifted to the accused, and he has to prove that he has not done anything wrong and the death of the woman is too remote and that it does not have any relation with the demand for dowry. So this is all for the concept. I hope you understand the same. Thank you.